Hello and welcome to the Pittsburgh Metro Lawyers blog site and also the Blissman Law Office YouTube channel and Facebook and whatever other social media that we've decided that we're going to put this on. My topic for today is just a brief overview of the options that you would have under the United States Bankruptcy Code. Through the years, there's been a number of changes, especially the big shakeup in 2005 when they put restrictions on the income level for people who would be qualified to file for a Chapter 7, which leads me to discussing the different bankruptcy chapters available. The most common is, in fact, a Chapter 7, whereby with your petition, all of your assets, all your liabilities, your income, and your living expenses are listed on your bankruptcy petition. And if the petition is granted by the bankruptcy court, you would receive a discharge on those debts. The exception would be, of course, for any type of government debts, such as back taxes, or if you owed some student loans. Generally, those are not dischargeable unless you could prove an extreme hardship in repayment. That is an extraordinarily high threshold. So generally speaking, those are not dischargeable. The other type of debts that would be at issue would be if you had any secured creditors. Now, those secured creditors would be the companies who would have liens against, say, your home. They hold a mortgage on it. Or if you purchased an automobile or a truck, motorcycle, anything that would have a loan in which the collateral is recited as the property that you have, such as you would have with a car, truck, or a motorcycle. On those, you have an option under the Bankruptcy Code under Chapter 7 in which you can indicate that you're going to ask for a discharge of the debt, meaning you'd no longer be legally responsible for it, but at the same time you'd have to surrender that property and you would have to turn it over to the creditor, and they would then dispose of it. You'd no longer own it. The other option is that you could get a discharge of the unsecured debts. You could indicate to the court that you're going to reaffirm your security interest in either the mortgage on a home or the loan on a vehicle. And you would, of course, have to keep paying on that, and you would continue paying and owe on that debt, even after there was a discharge granted in a Chapter 7. Now, the debts that they would discharge in a Chapter 7 would be generally unsecured, what is called non-priority debts, meaning that they're not government obligations, they're not secured obligations. Generally, credit cards and unpaid medical bills, things like that would fall into that category. And those are actually the bulk of the debt that people have. And generally speaking, on the secured collateral, most people want to keep their cars and keep their homes unless simply they bought too inexpensive a car or a home. Most people opt to keep those items. Now, on the unsecured debt, you would get your discharge on those debts, meaning you would no longer be legally responsible paying those debts. There would be a public hearing on the case called a meeting of the creditors. This would be scheduled after your petition was filed. And at that meeting of the creditors, you would have to appear as counsel, as your counsel, legal counsel would have to appear. You would have to bring two forms of identification, your photo driver's license or some sort of government-issued photo identification. You would also have to bring your Social Security card. Once you've established your identity, you'll be sworn in, and they'll ask you questions about your bankruptcy petition, the types of debts that are on there, your income level, whether you're going to receive anything of value in the near future. They might ask you questions on the value of your real estate. They certainly will ask you what caused you to file your bankruptcy petition. Generally, the reason is that it's been overspending or loss of income. Now, once the meeting is opened, the Trustee is going to open the floor to any possible creditors who might have questions about your petition. Also, they're going to look at your documentation. We're going to have proof of your income for the last couple of years and your pay stubs for the last 6 months. And then once the questioning is over from the trustee and they've given opportunity for the creditors to ask their questions, then we'll close the meeting. Ultimately, we want to have it considered a no asset case, meaning that every asset that you have, we have exempted, because under the bankruptcy code, unlike what a lot of people think, you're not going to lose everything. You're entitled to exemptions in which you can keep real and personal property. Now, of course, these amounts, there's up to certain amounts, those change all the time. Generally speaking, on real estate, if you have equity in a home and you're paying on it or you own it outright, it's generally in the ballpark of about $22,000 as I film this today. That could change after we film this. You would have to check with our office to make sure about the valuations of the properties and the items you have to see if they would qualify. Also, on motor vehicles, generally, it's about $3,400. You have exemptions for household items. It's pretty rare we can't get exemptions for everything that a normal Chapter 7 bankruptcy petitioner would have. So generally that falsehood, the folklore of losing everything you own, that's not true when you file bankruptcy. And there's other chapters that are available to you. The second most common would be a Chapter 13 case in which there's a scheduled organized plan of payments approved by the bankruptcy court. Generally, the plans would last between 3 to 5 years. It would be generally 3 years if your income is lower, but for some reason you had to file 13, such as you have a lot of equity in a home, or you owed a big tax debt that you couldn't get a negotiated repayment plan with the IRS. Or perhaps you had filed a Chapter 7 case within 4 years prior to filing the 13 case. Sometimes you find you have to seek the protection of a 13 petition. Chapter 13 debts, of course, you would have to pay according to the plan. They would take into consideration your living expenses and any disposable income, so-called disposable income. They would then incorporate that for payment to the creditors. First priority, of course, would go to the secured creditors. And the plan would be submitted by us with your input, and if it's approved by the bankruptcy court, that's the plan you would be paying. There would be periodic reviews of that plan, and there would be changes to it if there was, of course, any change in your income. Some people either end the 13 early or they go the full route. Now, if you go the full route, you'll receive a discharge on the unsecured debts. Of course, you would have had 3 to 5 years of payments. The 5 years would be if your income level was above, say, if you had qualified for a Chapter 7 case. But it gives you relief if you're not qualified for a Chapter 7 case or due to certain reasons, whether it's through the bankruptcy code or personal. You have that option under 13. Chapter 11 is available for businesses that need to do a reorganization of their debts, and also individuals with substantial assets. And then you have Chapter 12, which is unusual here in Western Pennsylvania, in that you'd be either a family farmer or a fisherman, in which you need to reorganize your finances. I've given you a broad overview of the bankruptcy code and how it works. If you have any further questions, feel free to contact our office. We'd be more than glad to talk to you over the phone or schedule a free appointment to go over what your options are under the bankruptcy code. This is Roger Blissman from the Blissman Law Office. Thank you.